Welcome back and thanks for staying with ANN7 Prime with me, Cindy Mabi. President Jacob Zuma has filed an application for leave to appeal the North Gauteng High Court ruling that says Deputy President Cyril Ramaphosa should appoint a new NPA boss as Shaun Abraham's appointment is invalid. The president argues that Ramaphosa cannot appoint a new NPA head as two people can't be exercising presidential powers. In a ruling handed down last week, the court gave the Deputy President 60 days to appoint a new NPA head after judges found the appointment of the current NDPP was invalid. President Zuma is also appealing that part of the ruling.
It's now up to Judge Dunstan Malambo and the full bench who made a decision to set aside the appointment of Shaun Abrahams as the head of the NPA to decide whether the president will be granted leave to appeal. In my opinion, I think they will not grant him leave to appeal. I think that they will say that there's no prospect of success if he was to appeal that decision, in which case he would have to petition the Supreme Court of Appeal in Bloemfontein. And same instance there, the court needs to apply the test, and that is whether the court a quo, so in other words, the court who made the decision made the correct decision, and secondly, whether there's any reasonable prospects of success of that appeal. And once again, I do not foresee the Supreme Court of Appeal finding in the president's favor, in which case he is free to approach the Constitutional Court.
And here are the reasons cited by President Jacob Zuma to appeal the ruling. One, he says the court erred in holding that the president is unable to appoint the NDPP and yet able to perform his other functions. And secondly, Zuma's lawyers argue the court erred by making it constitutionally permissible for two people, that is Zuma and Ramaphosa, to exercise the same presidential power.
My simple, humble view on the matter is that we are likely to see the old tactics by the president wanting to drag this issue further and further, in a way delaying the matter not to be resolved as quickly as possible, given the fact that he still has some time in the office to spend until 2019. But the danger is, will the FCA in Bloemfontein as well as the Constitutional Court be sympathetic to that kind of political behavior remains to be seen. And my humble view on that alone is that both courts might not find sympathy on his behalf to drag this matter further.
I'm joined on the line by Advocate Craig Philander from the Progressive Professionals Forum as Head of Legal. Mosiri Tsiane is with Mosiri Attorneys. He joins us in studio. And Paul Ngobeni is a legal expert joining us on the phone line. Good evening to you, gentlemen, and thanks so much for your time. Let's start with you, Mosiri, in that we've been here before in the whole contestation between what the Constitution permits in terms of the executive powers of the President and what the judiciary can then instruct him to do in this particularly complicated case of state of capture.
I think in by and large we've had various cases. In particular, one can refer not so long ago, a case that was brought by the opposition party in trying to say to the Speaker of Parliament that she ought to be having a secret ballot. And the Constitutional Court said that when the Constitution itself has dictated what should happen, the priority or rather the discretion relies squarely on the shoulders of the sitting speaker. So in this regard, same applies. When the Constitution has made it a directive, and it's there in the Constitution, the powers that are there of the state president, you cannot, as a court, amend that without having to amend the Constitution. And to amend that Constitution, it has to be done in Parliament. It has to have a two-thirds majority so that you can change that. For as long as it is, that judgment remains what it is, but up until the Constitutional Court will remain or give a judgment in it and say that it cannot unilaterally as a court amend the Constitution. The prerogatives and the powers of the state president remains what they are. The fact that the state president seems to be conflicted, which is an insinuation, or rather because there is a case relating to him, does not necessarily then change the powers of the state president. It can relate to Jacob Zuma, which is something else. Here we're talking about the president's power, which are given in that constitution.
Let's get a view from Advocate Advocate Craig Philander from the Progressive Professionals Forum as Head of Legal. Good evening to you and thanks so much for joining us. Again, is there merit in the argument by the President's Counsel that he cannot be absolved of his functions in its entirety, and yet the court seems to have just selectively chosen what he can do in this particular case?
Good evening, Cindy, and good evening to the viewers. Cindy, I don't want to necessarily focus the attention on the particular cases. I think there's a serious problem in our country, and I want to answer it like this, that education about our Constitution seems to be lacking. So what indeed happens is that the courts have now started an interpretation of the Constitution the way they think it should be interpreted. So we need to be very mindful of the rights and the obligations of certain functions of our institutions. So our Constitution and the democracy that we built on is built on the separation of powers. And I think this is very important. So the essence here is, what does the judiciary do? What does the president do in terms of his cabinet? And then, which is the executive, which is also known as the executive, and then what is parliament. Each one of those foundational democratic institutions have their functions and powers. And these functions and powers are in the Constitution. So what has happened in these cases, and I want to say cases, basically the court has then decided to break the law, okay, and really disregard the Constitution as it is. A court can pronounce on its findings. It then has to then subscribe to what the Constitution says. It cannot do as it pleases because it's guided by law. It's not guided by its own interpretation. Therefore, it is so important that when we go forth on any of these discussions, that we don't necessarily start accusing and making finger pointing. What needs to happen here is we all need to understand who does what, where, and when. And in this instance, the court has overstepped its boundaries. Not particularly, I don't want to discuss any of the particular cases, and the discussion obviously resolves around cases, but it is about the powers and functions of those three very important institutions of our country.
Stay on the line with us, Advocate Philander. We have Paul Ngobeni, who is a legal expert. Good evening to you, Mr. Ngobeni. Much appreciated, and thanks for your time. Again, the issue of imposing the court ruling on a sitting president to now suggest that a certain function must be fulfilled by the deputy president in appointing the NDPP head, because we know there's the cloud, as the court had said, that he's implicated or may not be impartial in appointing a new NDPP head. How does that then give the weight behind the arguments of the president, saying that there aren't any two presidents and therefore the functions in its entirety needs to belong, the executive authority still rests with the president?
I think there is much force to that argument, but I would actually, my starting point will be that the perceived conflict is actually imagined at this point. If you recall, the SCA made a decision declaring the withdrawal of the charges against the president to be invalid. But it also sent the matter back to the NDPP for a fresh decision as to whether or not to charge the president. At this point, no one, including the Judge Mlambo and his panel of judges, no one knows what the NDPP will decide. So to talk of conflict under those circumstances, where Judge Mlambo has already declared, he's already prejudged the case, in paragraph, in his judgment, he has mentioned that that's paragraph 114 of the judgment, where he claims that there are no longer any obstacles in the way of the criminal charges proceeding. But he doesn't know that, because at this point, the NDPP has been instructed by the courts to go and apply his mind to the matter and make a fresh decision. So it's an imaginary conflict of interest. So in terms of whether or not the Constitution even allows that, I think when we talk about separation of powers, we need to be mindful of the fact that sometimes all that the court can do is to declare certain conduct inconsistent with the Constitution, and then leave it again to the executive to decide on how to comply with that court order. But you don't go ahead and try to micromanage how the executive handles certain matters. I think you may recall there was an SCA decision regarding the charges against Mdluli, where the High Court decision, which was instructing the executive to reinstate charges against Mdluli and to do so within a certain period, where that was set aside by the SCA on the grounds of separation of powers, where the SCA specifically said the court can declare certain acts unconstitutional, but it cannot go further and instruct the executive on how to manage its affairs. And I think when you have a court that not only pronounces that, yes, there are no longer any legal obstacles and Zuma must stand trial, while at the same time the NDPP is still applying its mind to it, the court is actually preempting that and insinuating itself into a process which belongs to the executive and not to the judiciary.
Yes, please stay on the line, Mr. Ngobeni. And Mosiri, in the sense of there was already a process in place of making fresh submissions by both President Zuma and divested interested parties, that, there needs to be a revisit of the case, whether charges will be reinstated or not. What does the judgment from President Judge Mlambo then do in disrupting that particular process? And does it aid in concluding this case expeditiously as possible?
No, it doesn't. Fairness and honesty doesn't. What it does, rather, is that it pours more clout into it and say that, whatever Shaun Abrahams can decide on, whatever decision he can decide on, should be influenced or it's expeditious in its own nature, either to make sure that before Shaun Abrahams can actually move away from his position, that he makes a decision in favor of the president. Now, that is what it says. It tries to drive that decision of the NP and say, you cannot take this decision, because if you take that decision, we would only assume that you are doing it in such a speediest manner in order to avoid you leaving the office because there's an adjustment. That's what it does. But above it all, when a judgment is made by a court that seems to create an impression that any judge in South Africa appointed by the president would be in favor or will act in favor towards the president. I don't know what is that court trying to give an impression to South Africans, because in general, all judges are appointed. At one stage, there was a crisis and hullabaloo noise about the appointment of Mogoeng, with expectation that he might always be favoring the president because he was appointed by the president. Later, we all know that that is not so, that we've learned to know that the Constitutional Court is, at its own nature, the fairest of them all. But why create an impression that anybody appointed by the president will seek to make sure that whatever decision he does, because that's the impression that is given, that if you are appointed because you are conflicted here, whoever it is will do things in your favor. But that has not been the case in so far.
Yeah, but Advocate Philander, I mean, what the Deputy President can or cannot do rests on the time frame or prescription as per the court ruling that he has 60 days to appoint a new NDPP. In the meantime, President Zuma will still be president within those 60 days. That is depending what the ANC does after the elective conference. But the Deputy President can't move either way, otherwise he'd be in contempt of court. Is that correct?
Yes, correct. I think I almost want to answer the question like this. If you remember the Nkandla judgment, and I think this is a very important judgment in South Africa, what happened there, and I think the court in the Shaun Abrahams matter didn't actually go as far as applying its mind to that. But I'll deal with that just now. The thing here, what happened is that at the time the pronouncement of the Constitutional Court says, no, this matter must go back. I'm talking about the Nkandla matter. It must go back to Parliament. Parliament, you erred. You should have held the President accountable, because the the Chief Justice at the time, did say that that is your role as the legislature. It is your role to keep the executive in check. He didn't take that responsibility on himself. So it's kind of interesting that a lower court, which is a full bench, then does exactly the opposite to what the apex court does. Because the apex court is the constitutional court. You can't go further than that. But yet, the lower court decides, well, we don't actually like sending this to Parliament because we've already seen what goes on in Parliament. They've had about 3 or 4 no votes of confidence, if it's not more, and on both occasions the opposition has lost the vote against the president, the current sitting president. So clearly, in that respect, the decision is flawed in itself. So the deputy president cannot assume authority over powers that doesn't even reside with him. So how can the power even go across to him if the procedure within the Constitution was not followed? So therefore, there's a constitutional crisis at the moment. What needs to happen is that Parliament, as well as the executive, they need to step in. They need to urgently meet with the judiciary and really have this conversation and really set the tone for the future. Because we cannot have decisions that is contrary to the Constitution. If we say we're a constitutional state, then we must live up to the Constitution. We can't break it as we please and as we go along. Yeah. And that is what the Constitutional Court did in Nkandla judgment.
All right, Mr. Ngobeni, just to make sense of it legally as to what would have led to the full bench of the Gauteng High Court and including Judge President Mlambo to come to this decision, if the law and the Constitution is unambiguous in terms of the powers of the Deputy President vis-a-vis what the President can do?
Well, what would have led them to that? One has to read the whole judgment, and interestingly, there are a lot of false assertions that are made in the judgment itself. I know you don't have time to go into it point by point, but I'll point out that there's a section in the judgment where the court is claiming that there was a criticism of certain advocates, Jiba and Mkhwebi and Mzinyati, and that adverse criticism was affirmed by the SCA. When you go to the SCA judgment, there is no such thing. So this is a situation where the court was crafting a narrative that is simply untethered to the facts. It's not based on facts. It's based on the court's own narrative that simply is false. So if you were to read the judgment very calmly, section by section, you are going to find that there are allegations that are made in that judgment that simply are not based on facts. There are errors that appear on the judgment that, if appealed, even before you go to the larger constitutional issues, because the court's reasoning that led to that conclusion, think of it as a sort of a building block. If they start with false allegation about certain fundamental issues, and they claim that the SCA had affirmed certain things when, in fact, the SCA judgment was just the exact opposite. It overturned a high court ruling which was critical of those advocates and actually vindicated them and said that they acted lawfully in withdrawing certain murder charges against Mdluli and so forth. So we have a problem where even just an honest presentation of the facts was lacking. And the issue of the constitutional crisis, where you are saying that the president who appoints a deputy and who may dismiss that deputy president at any time, that you are going to create sort of two centers of power, that the deputy is going to perform the function of appointing NDPP because you claim the president is conflicted. But the president, under the Constitution, has a right to fire the deputy at any time.
Mr. Ngubeni, stay with us. I just want to also get to the point whether the court can prescribe or nitpick what functions based on the extraordinary circumstances or whatever aggravating circumstances that the court may find. Can they nitpick and say the president under the condition where he is incapacitated, for example, or if he is found to have committed perjury, etc., therefore certain functions must be concluded or performed by the deputy president?
It's rather bizarre that you have that is not picked, or rather a pick and choose of who should do one, two, or three functions in absence of that. But it's right to say that certain responsibility are necessarily belonging to the executive in itself, and allow that space. If you have a motion that succeeds with a president that has other crossed the line in this regard, and Parliament feels that he no longer deserves to be a president, then you will appoint a new president. The powers and the functions of that president will automatically come to the president, and it doesn't belong to a particular individual. Would you have had a successful, for argument's sake, a successful coup that was intended by the opposition party, you would obviously have, I doubt that the judgment would have been a bit different from where it is now. I suspect it would have completely been different, because it would have said, now that it is a different person who is a president, now let him exercise his powers and duties given to him by the Constitution. You cannot create new functions which were never there. You cannot have a separation of power in that instance where you have an absolute sharing of power. In actual fact, you have two centers of power. It's not there in the Constitution.
Yeah, very straightforward, Advocate Philander. Is there a subjective interpretation? And I pose that to you, Mr. Ngubeni, as well, whether indeed this ruling had been objective and impartial. I'll start with you, Advocate Philander.
Yes. You know, Cindy, when I hear the judge makes certain obituaries about the president, you know, I've tried to explain this matter to people and say to them, you know, over a weekend, and I like to use examples because it's practical. I'm the chairperson of a federation, a football federation, and I sit on my couch and I point out and I say, I don't like this player, you know, and this is on my couch. When I get to work on Monday, I cannot say that, because that role of mine, being the FA president, means that I have to like all the players, even though I don't like one player. So what I'm trying to say in my example is that when a judge enters the courtroom, he is obligated to treat every person in front of the law equally. There cannot be a situation where you actually say, in an open court, but you have had an opportunity to have done that. You have not done that. And he says this. He says it openly. And it then says that there is an innate dislike towards the current president. Now, that said, already you see there's a sense of maybe anger, maybe disappointment. I get that. That is human. But as a judge, and a senior judge at that as well, you can't do that in a democratic state.
All right.
Because we need people to be objective in the court.
Advocate Philander, we're going to leave it there. Thank you so much for joining us. Very briefly, Mr. Ngubeni, in the sense that, has Lady Justice been blind from any influence or manipulation, in your view, in this matter?
Absolutely not. In fact, if you read Judge Mlambo's judgment, he comes close to confessing that he has used President Zuma's prior litigation position and his lawyers' statements in which he says that President Zuma will use all available legal means to defend himself. He views that negatively, and he says it's in part for that reason that Zuma will resist prosecution. That is actually removing him from making any kind of decision about appointment of an NDPP. And that is why he has he has instructed that a deputy perform the functions of the president. So that is clear admission of bias, that to say you are biased against a party because he has exercised his constitutional right like any other criminal defendant in a case will do.
All right, we're going to have to leave it there, Mr. Paul Ngobeni, a legal expert. Thanks indeed for your time. And as always, much appreciated for your insights as well, Masiri Tsiane from Masiri Attorneys. But in 30 seconds, the prospects of success of this appeal.
It's going to succeed, but it's going to succeed at the Constitutional Court, because that's where clarity will be placed about responsibilities, about separation of power, about overreach. That's what's going to happen. It's going to be a success.
All right, we'll leave it there. You at home, thanks indeed for staying with us. You can join us on social media at ANN7 TV, or you can live stream on our website. We take a quick break. We'll see you shortly.